Good morning, all. This application hearing is in the matter of CFI 019-2025 and is being held by way of video conferencing before His Excellency Justice Thomas Bathurst, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is Mr. Atul Dhawan and is a litigant in person. The defendant is represented by Al-Tamimi and Company. Lead counsel is Mr. Matthew Watson. Thank you, Your Honour.
Thank you. Mr. Dhawan and Mr. Watson, I've read the skeleton arguments, so you can take it I've got some familiarity with the case. Mr. Dhawan, I've read your argument. Do you want to add anything to it?
Not really, My Honor. Whatever the two arguments I had, I have already put it into the system, which is the breach of contract, and which is basically how the breaches have been done over a period of time, which has caused me losses and trouble, and the claim for jurisdiction, which I've also given the documents proof of that. That's it, sir.
You understand today we're only dealing with the question of jurisdiction.
Right, sir.
Now, have you read Zurich's skeleton argument?
Yes, sir.
And you'll see that do you have it with you, or I want to ask you a couple of questions about it.
I didn't get that, sir.
Do you have Mr. Watson's argument with you?
Yes, sir.
You'll see that he raises a number of arguments as to why this court has not got jurisdiction.
I read that, sir.
Do you wish to say anything in response to that?
Yes, sir. I have put in my application form very clearly that all my meetings happened in DIFC area. I have a letter from them which I have given as proof, which is the DIFC office as the address. My claim form for this particular policy, which was in 2015, also was done in DIFC when I was called, and the reinsurer took my medical conditions there, which was in the first cases also. Unfortunately, when Zurich put this application into the system, they removed the 4 pages, I don't know why, which claimed and showed the connection of all the 5 policies I have with them. Okay, but I've submitted that to the court again from my side. And then there is one book which Zurich always gives us when the agent comes to us, which says, irrespective of what the place would be, if the client goes to any court of law, Zurich will comply and come to that court. So that confirms whatever they have said in the document and the form which I have.
Very well. Mr. Watson.
Your Honour, I propose to deal with this in 3 parts. I think Your Honour was asking Mr. Dhawan just then various questions about where the contract was concluded in its nexus with the DIFC, which I will come to. But I intend, unless Your Honour wishes to do something different, to go through each of the 3 points that are in my skeleton argument and develop them.
I'm happy that you do that.
Your Honour should have access to the electronic hearing bundle. I should just flag that after skeleton arguments were exchanged, we became aware of some additional documents that Mr. Dhawan had filed. They are in the bundle from page 1454. I'll deal with them as necessary. In my submission, they don't change anything. Mr. Dhawan is obviously in person, and for that reason, subject to Your Honour, I may go a little slower and deal with things a little more fully than I might, so that Mr. Dhawan can understand the case that he has to meet.
Mr. Dhawan, you appreciate that after Mr. Watson is finished, I'll give you an opportunity to say something in reply. So if you could just listen to what Mr. Watson says, and if you don't understand it, you can tell me at the end of his address.
Perfect. Thank you, my lord. I'll wait and listen.
Yes, Mr. Watson.
I summarised in my skeleton the basis of the claim, I hope fairly, to Mr. Dhawan. I don't intend to go over that in detail or to say anything about the merits. Obviously, this hearing is just about jurisdiction. I'm also conscious that I do not think Mr. Dhawan has ever actually identified the precise jurisdictional gateway into which he says his claim falls. And Your Honour will have seen from my skeleton argument that I've identified what I thought were the three gateways being relied upon, which is Article 14A1, the DIFC Establishment Gateway, and then Article 14A2 and A3, which are, as it were, the subject matter gateways, which capture claims where the subject matter has a nexus with the DIFC because the contract is concluded in the DIFC or is performed in the DIFC, or there's some incident or transaction in the DIFC.
I rather assumed that was what he was relying on, but you go ahead.
So I'm going to address each of those in turn and then develop the third point, which is to do with the UAE insurance law, which does raise some rather more novel issues for this court. Before I get into my submissions, just to deal with a couple of matters of principle. Obviously, the court's jurisdiction is established if Mr. Dhawan can show that the claim falls within one of these gateways. When the claim was issued, the judicial authority law was the relevant law. That law was repealed and replaced by the DIFC courts law in March of this year. I explained in my skeleton, Your Honour, in section C1, why the DIFC court applies the jurisdictional statute in force at the time of the hearing. So my position is that Your Honour must apply the DIFC courts law. And that really arises out of a DIFC Court of Appeal decision from 2012 in Al-Kharafi. I can take Your Honour through it. I don't know whether this point is disputed by Mr. Dhawan. Equally, I'm happy to leave it, and Your Honour can look at the relevant paragraphs of the judgment. I'm entirely in Your Honour's hands.
Could you just explain for Mr. Dhawan what you say the principle is? I don't need you to take me to the cases.
No, the principle is that both in the UAE, and that's referring to the onshore courts, and also in England, the courts adopt the view that matters of jurisdiction are a matter of public order or public policy. And as a result, they are an exception to the usual rule that a statute does not have retrospective effect. And so the DIFC court, in the decision in Al-Kharafi, the Court of Appeal held that a jurisdictional statute has force from the moment that it is enacted in relation to court, in relation to cases that are live before the court. And so when the court is dealing with a jurisdictional question, it has to apply the most up-to-date jurisdictional legislation. The particular issue in Al-Kharafi is that the case was heard at first instance. There was an appeal from the then Chief Justice. And before the appeal came on before the Court of Appeal, the ruler had enacted a change to Article 5 of the Judicial Authority Law, which changed the text of the jurisdictional limbs. And so the first question for the Court of Appeal is the case to be decided on the basis of the jurisdictional statute as it was at first instance, or as it was when the appeal was being heard? And the conclusion at paragraph 6 of the court was of the judgment was that it's the jurisdictional statute as in force at the time.
Yes.
In addition to the statutory source for jurisdiction, the other relevant principle is the standard to which Mr. Dhawan must establish any disputed fact relevant to jurisdiction. And here the DIFC court follows the test in England that a claimant must establish a good arguable case. And what does that mean? It means there must be a, quote, a plausible evidential basis. And I've set out at paragraph 18, Your Honour, of my skeleton, the English test. Your Honour will find an extract of DIFC courts practice. I won't take you to it, but for your Honour may even have it. I won't take you to it. It's at pages 52 and 53. If Your Honour can have a look if you want. I should say, full disclosure for the benefit of Mr. Darwin, that I'm one of the contributors to this work, but I did not write this chapter.
Where is this written?
Mr. Darwin will find this at page 733 in the bundle. And Your Honour can see at paragraph 2.94, a claimant is required, it's at the bottom of page 52, a claimant is required to establish that it has a good arguable case that one of the jurisdiction gateways is satisfied. And there's Al-Kharafi again, a decision that crops up a lot in jurisdiction contexts.
Yes.
And then over the page, on page 53, paragraph 2.96, in England, the good arguable case test for jurisdiction has been the subject of a judicial discussion in various cases. And then the English Supreme Court established a three-stage test. Claimant must supply a plausible evidential basis for the application of a relevant gateway. If there's an issue of fact or some other reason for doubting whether it applies, the court must take a view on the material available if it reliably can. But the nature of the issue and the limitations of the material available at the interlocutory stage may be such that no reliable assessment can be made, in which case there is a good arguable case for the application of the gateway if there is a plausible, albeit contested, evidential basis. So that is the test for Your Honour. Whenever there's an issue of fact, what Mr. Darwin has to do is to show that he has a plausible evidential basis, even if that is contested. And then the text cites that the principles have been adopted in the DIFC. So I'm going to move then to the first gateway, which is this question of
this book.
Sorry, Mr. Darwin.
Yes, sir.
I thought you were addressing the court. I am sorry.
Yes, I just wanted a document out, so I was just taking a piece of paper back. Sorry for that.
That's all right. Yes, Mr. Watts.
So the first issue is whether Mr. Darwin can establish jurisdiction on the basis that Zurich, the defendant, is a DIFC establishment. In my submission, he cannot. And I'm going to take this point in two parts. What I'm going to do first is deal with the construction of the DIFC courts law, and then I'm going to deal with the application of that to Zurich. If I could ask Your Honour to turn to page 713 in the bundle.
Yes.
This is Article 14 of the Courts Law. And the relevant gateway that we're looking at for the moment is Article 14A1. The DIFC courts have exclusive jurisdiction to hear and determine civil or commercial and employment claims and applications by or against DIFC bodies or DIFC establishments and those to which DIFC bodies or DIFC establishments are party. So essentially, this gateway asks the question, is the claim brought by or against a DIFC body or DIFC establishment? And there's no dispute this is a civil or commercial claim, for instance. Now, I don't think it's suggested that Zurich is a DIFC body. I think the issue is whether it is a DIFC establishment. And Your Honour will find the definition of that term at page 708.
Yep.
And Your Honour can actually see just above the definition of DIFC bodies, which are bodies established and regulated in accordance with the law. And that covers things like the DIFC authority, the DIFC courts themselves, the administrative structure, things like that. So the you've got a definition of DIFC establishment, which is actually in two parts. And the second part stands alone, and it's the words at the end of the definition, including licensed DIFC establishments. So you are a DIFC establishment if you are a licensed DIFC establishment. And if your honour looks down the next definition, you can see the definition of a licensed DIFC establishment, which is any entity or business licensed, etc., by the DFSA to carry on financial services. Now, Zurich, the defendant, does not, and as far as I'm aware, has never had any license or registration with the DFSA. So it is not a licensed DIFC establishment. There is another company in the Zurich group that is DFSA registered. That's Zurich Insurance Company. And for your honour's note, I won't take you there now, page 85 of the bundle has got the public DFSA registry entry for that company. So your honour can have a look at it if you need to. But that's a different company and no claim is brought against it. And jurisdiction under this gateway is not established simply because the defendant is part of a group that includes DIFC establishments. Because the test is whether a claim is brought by or against a DIFC establishment, not whether a claimant or defendant has a DIFC establishment as a parent or as a subsidiary.
What's meant by the words or business license? I can understand entity license. How do you license a business?
I think, Your Honour, that is probably intended to capture non-incorporated businesses. But quite how non-incorporated businesses actually operate in the DIFC is quite a difficult question. I mean, as a self-employed barrister in England, I am a business, but I'm not an entity. I'm in the business of supplying legal services, but I don't operate through a company. And so I suspect it would be designed to capture me to the extent that I fall into the rest of the definition or something like that. So coming back to the first part of the definition of a DIFC establishment, it requires that there's an entity or business, and I accept that is satisfied. Zurich is an entity; it's a company incorporated in the Isle of Man. So the question is, what does it mean to be established, licensed, registered or permitted to operate or to carry on any activity in or through the DIFC pursuant to DIFC laws and DIFC regulations? And in my submission, mere establishment, licensing, registration, etc. is not sufficient. The complete test is that you have to be established, licensed, etc. for a purpose, namely to carry on some activity pursuant to DIFC law. So in order to test whether an entity is a DIFC establishment, Your Honour is not just looking for whether an entity is registered or licensed. Your Honour is also looking for whether it's registered or licensed under a particular law to enable it to operate or carry on an activity.
Yeah.
And Your Honour can see that test by contrasting this definition with the definition for licensed DIFC establishment, which follows a similar structure. It's not just that you're licensed, registered, authorised or recognised by the DFSA, it's that you're licensed, etc. by the DIFC to carry on financial services or ancillary services, i.e. there's a kind of conduct or activity nature added to the definition, whereas under DIFC bodies, it is sufficient that you are established and regulated. So your mere existence is enough to bring you within the definition and therefore bring you within this jurisdictional gateway. So perhaps against that construction, I can just briefly state the crux of my submission, and then I'll explain it by taking you to the relevant statutes. The defendant is a recognized foreign company in the DIFC. And when a foreign company is recognized, it is recognized under DIFC law for a specific purpose, namely carrying on business in the DIFC. And that's actually given a statutory definition, which I will show you. So for the purpose of the test for whether an entity is a DIFC establishment, when one asks of a recognized foreign company, what is the activity for which it is licensed, registered, permitted, etc. under DIFC law? The answer is carrying on business. And in order to carry on business, a recognized foreign company needs a commercial license. And without that license, it's not permitted to carry on business and faces fines if it does carry on business. And the reason why Zurich has no commercial license is because it is in the process of being deregistered. It gave up its license in November 2019.
Why does that matter for the purpose of jurisdiction? If the contract that Mr. Dhawan alleges was entered into prior to that time?
Because the test for jurisdiction is assessed at the date of the time when the claim was issued. So if you contract with a DIFC establishment, but it then ceases to be a DIFC establishment, the court would not then have jurisdiction over it under Article 14A1. And because it's the obverse of the point, for instance, that was established by Tavira, which is in the bundle, because in Tavira, at the time when the relevant facts occurred, the claimant, as it was not a DIFC establishment, but had become one when the claim was issued. And so the court said, we have jurisdiction because you are a DIFC establishment. Perhaps
where do I find that, Mr.
Perhaps I take you to it's page 954 in the bundle.
Yes.
And so the issue in this case was whether it was sufficient that the claimant had become there were various other issues as well, but the core jurisdictional issue was about whether the claimant had become a DIFC establishment at the time the claim was commenced, because it hadn't been at the time when the claim arose. And in accepting that argument, you get the summary by Justice Field at page 967 of the conclusion in Al-Kharafi. And you want to see there, paragraph 32, the question about jurisdiction the time at which jurisdiction is to be determined as the time at which the test for jurisdiction is to be applied, and not by reference to a time in the past. So the test is, it is irrelevant for the purpose of this head what the position was when the contract was concluded or all the material events occurred. Now that might be different under other limbs of Article 14. I quite accept, because Article 14A2 asks the question: is this a claim that involves a contract that was concluded in the DIFC? And obviously that question has to be answered by reference to where, the state of affairs when the contract was concluded. But the question whether you're a DIFC establishment is assessed at the time at which the test for jurisdiction is to be applied.
Yes.
And so what I'm trying to see is whether I can assist Your Honour by getting the commentary on this in DIFC courts practice, but I don't think it actually goes any further than Tavira. So questions about whether this was a contract concluded in the DIFC is something which I'll come on to when I deal with the other limbs. But for the purpose of whether you're a DIFC establishment, what matters is the position now. So as I was in the middle of submitting, the position we are today is that Zurich doesn't have a commercial license and hasn't had since November 2019, because it's in the process of deregistering. It's in fact done everything that it needs to do. That's in Mr. Davis's evidence. I won't take you to it now. It's just awaiting the administrative act of the registrar to remove it from the public register. And Your Honour can actually see that at page 95 in the bundle. This is the public register entry for the defendant. And Your Honour can see immediately under the name the words pending deregistration. So it doesn't say active, which is what it would say, and it says in relation to most DIFC entities. I don't know how often Your Honour has seen these. And you can see under entity details, legal structure, recognised company, date of registration, and then license validity. That's the date when it expired, as Mr. Davis says in his evidence. So it was November 2019. And it has, for reasons that I cannot explain to Your Honour, still not been removed from the register. But that's really a matter for the registrar. So
the crucial thing for your argument is the fact that there's no license.
Sorry, Your Honour, I missed that.
I'm so sorry. The crucial aspect of this for your argument is the fact that it doesn't have a license at the time.
It is. Yes, it is. That's quite right. Because if I can put it in this way, the defendant is in a twilight zone between being, on the one hand, a recognised foreign company entitled to conduct business, and on the other, the situation it would be in if it had been entirely removed from the register and therefore not established, registered, whatever at all. It's in this nether region. And in my submission, while it's in this state, it doesn't satisfy the test for a DIFC establishment, because whilst it may be merely registered, it's not registered to carry on the relevant activity, namely the carrying on of business. I just want to take you, therefore, through the relevant statutory framework, just to make good that point about recognition and licenses. I hope Your Honour will bear with me.
Yes.
If we could start with page 652 in the bundle. This is the DIFC Companies Law.
Yes. Yep.
This is part 12 of the Companies Law that deals with recognised foreign companies. And Article 133, 1, you've got a foreign company shall not carry on business in the DIFC unless it is registered as a recognised company under this part. And then at 2, the Board of Directors of the DIFCA may make regulations prescribing what comprises carrying on business for purposes of this part. And I'll take you to those briefly, but that establishes that that term carrying on business has a definition. You've then got a process at Articles 134 for registration, and Article 135 deals with the effect of registration. So the registrar's got to issue various certificates and assign company numbers. And then Article 136, you've got the requirement that a recognised company shall at all times, C, hold a licence pursuant to Article 9 of the operating law unless exempted. And I'm going to take Your Honour to the operating law in due course. And then over the page, Your Honour, this is now Article 136, little 3. It's in the middle. A recognised company which fails to comply with each of the requirements in this Article 136 is liable to a fine. So, and just to make good, Article 137, you're to comply with the requirements of the law in respect of your the conduct of your business. And one of the requirements of the law is that you hold a license. So if you carry on business when you don't hold a license, that is contrary to the law, it's unlawful, and you're liable to a fine. So that's the basic structure of the law. The company's regulation is at page 683. And this just sets out at the beginning, Regulation 7.1, that what you've got to do in order to register. And over the page, there are regulations dealing with names and certificates. And then at Regulation 7.4, you've got meaning of carrying on business. So carrying on business includes establishing or maintaining a place of business, administering or leasing property, operating as a reporting entity, or employing persons in the DIFC. And it's got various exclusions, so shall not include merely being a party to proceedings or holding a shareholders meeting or something. So a foreign company can be a party to proceedings without being recognised. That's entirely legitimate as a matter of regulation. But the question here is whether the court has jurisdiction over a DIFC establishment, i.e. whether the defendant falls within that definition. And in order to fall within that definition, it needs to be licensed or established to carry on an activity. And that activity is the carrying on of business, as is meant by Regulation 7.4.
Yep.
Now, I just want to show you very briefly the provisions of the operating law, which is the law that actually governs the licensing regime.
Yep.
So page 743 in the bundle, please, Your Honour.
Yes.
So it starts at Article 8 with a general prohibition. No person shall operate or conduct business in or from the DIFC unless that person is incorporated, registered, or continued under a prescribed law or any other legislation administered by the registrar. And then you've got Article 9, which deals with licensing. The registrar may issue licenses, permissions, and exemptions. And then Article 2, subparagraph 2 here, a registered person and any other person who operates or conducts business from the DIFC to whom a license has been issued shall maintain at all times a valid license as prescribed in the regulations. And then at little 5, a person referred to in Articles 9, 2 or 3 shall only conduct the activities that are permitted under that person's license or permission. So you've got to have a license to conduct business. If you're a registered person who operates or conducts business, the registrar is going to issue you a license, and it must be maintained valid at all times, and you've got to comply with its terms. And then over the page at 744, you've got a person referred to in Article 9.2 shall make an application to the registrar for the renewal of its license in the manner prescribed in the regulations, along with the relevant fee, unless it has A, ceased to carry on business in the DIFC, and B, given to the registrar the notification prescribed in the regulations. And then failing to comply with Article 9.10 gets you an automatic fine. So when you are a recognised foreign company, when you are registered, you're issued with a license, and you must maintain that license in order to be lawfully entitled to carry out business in the DIFC. And the only circumstances in which you're not permitted to renew that license is if you have ceased to carry on business in the DIFC. And that's, as it were, begun the process of deregistering. So that's the way the legislation works. And in my submission, there's a sort of logic to how the Article 14 gateways are working, because what 14.1, 2, and 3 are all doing is asking the question about whether there is sufficient nexus with the DIFC to engage jurisdiction. Because as we will see, Articles 2 and 3 are about the nature of the claim. We'll come to those in a minute, but they're to do with, is this a contract that was concluded in the DIFC or performed in the DIFC, or was there an event or an incident in the DIFC?
Under Article 14.1, the sole protecting factor, if I can call it that, is being a DIFC establishment. Wouldn't matter where the claim was, subject to any other principles, it wouldn't matter where the claim was made.
Right. Absolutely, and indeed, there's DIFC authority on that. So, a famous decision in Corinth, which you will see discussed in DIFC in court's practice. In Corinth, all the relevant events happened in Switzerland in relation to a branch of a bank. I think it was Barclays, and a claim was brought in the DIFC because Barclays is a regulated entity in the DIFC, and Barclays said, "Well, wait a minute. All the events of the claim are connected to our branch in Switzerland." And the court said, well, that might be material for an argument about forum non-convenience, but you are a DIFC establishment, and therefore this court has jurisdiction over the claim. So what Article 14A1 is getting at is the identity of the defendant, and whether it's got a sufficient nexus with the DIFC to justify the DIFC court taking jurisdiction over it. And in order for there to be
that provides some rationale. The relevant time one looks at the matter is at the time the jurisdiction sought to be invoked.
It does, Your Honour, and that's why what in my submission the law does is it goes just a little stage further than being merely registered. You've got to have a more substantial nexus with the DIFC, because you're entitled to carry on business here. Now, it may be that you don't, but maintaining a license entitles you to carry out business in the DIFC, and that's what the ruler has said justifies the DIFC court having jurisdiction over claims against you, subject, of course, to questions about forum non-convenience and things like that. And so that's why the mere fact that you're on the register isn't enough when you're in this, as I call it, the twilight zone. Just to complete the statutes very quickly, if Your Honour could just turn to page 782 of the bundle.
Yeah.
So this is the operating regulations. So these are the regulations that support the operating law that we've just been looking at. And Your Honour will see regulation 2.1 simultaneously with the issue of certificate of incorporation, registration or continuation. The registrar shall issue that person with a commercial license. And just to help to explain it to Your Honour, you'll see 2.2 deals with an operating license. So if you're a non-profit or a foundation, you get an operating license. If you're a business, you get a commercial license. Regulation 2.3.3, the following registered persons must hold a commercial license. You'll see it's public company, private company, and then at C, recognised company. So that's the foreign recognised company. And just for good measure, at page 785, you'll see there's some supplementing regulations here about renewal, and at regulation 2.94, if you do not seek to have your license or permission renewed, you've got to notify the registrar using the prescribed form of that intention and the steps it proposes to take to terminate its operations, registration, etc. And our evidence is we've done that. We've done everything that we think we need to do. We're just waiting for the registrar to remove us. So, drawing all of that together, is Zurich established, licensed, permitted, registered to operate or carry on an activity pursuant to DIFC law? As at today, or indeed when the claim was issued, the answer is no. It was registered to carry on business as a recognised foreign company, and it is still notionally registered, but it is not permitted to carry on that activity because its licence has expired. And so if I can encapsulate it this way, Zurich is essentially defunct in the DIFC and awaiting the administrative formality of being removed, and as a result does not satisfy the test of a DIFC establishment.
Yes.
So I propose now to move to the other two gateways. I can hopefully take this a little bit more swiftly. So if Your Honour could turn back to page 713. I can see Your Honour's got it in hard copy. I don't know whether taking page 713 out physically so that Your Honour can keep Article 14.
I'll do all of the conclusion of the hearing as to what's. If I do it now, I'll never find the pages again.
Okay, that's fine, Your Honour. So limbs 2 and 3, I was going to look at 2 first. These are civil commercial employment claims arising from or related to contracts, whether concluded, completed, or performed wholly or partly within the DIFC, or which will or should be performed wholly or partly within the DIFC, as expressly provided in such contracts. So you're looking for whether the contract was concluded, completed, or performed in the DIFC, and that can be, and partial conclusion, completion, or performance is sufficient, or a contract that will be performed in the DIFC as expressly provided. So you've got to look at the express terms of the contract.
That only the caveat only applies to the second limb of that definition, I think, doesn't it?
Yes, as it were. Yes, as expressly provided. That only applies to will or should be. So if you're looking at future performance, I don't think there is a case that this contract was performed or should be performed in the DIFC. I think the allegation is that it was concluded in the DIFC. And I'm going to deal with that in a moment. But Your Honour will, just as a backdrop to this submission, Your Honour will recall from my skeleton at paragraph 39 that Zurich is not regulated by the DFSA to act as an insurer in the DIFC. So in my submission, before Your Honour even gets to the evidence, it would be inherently improbable that Zurich was concluding insurance contracts in the DIFC, because that would entail a reputable global insurer breaching the DIFC regulatory law. Obviously, don't say it's impossible, but it is inherently unlikely, given that Zurich is not regulated to carry on a financial service, namely entering into contracts of insurance from the DIFC, that it would do that, because that would be to breach the regulatory law. So that's
the other evidence would have to be considered in the context where it was inherently, you say it's inherently unlikely.
Exactly.
That Zurich would be breaching the law.
Exactly. So I'd like to look at the evidence then for where and how this contract was concluded. The first is Mr. Darwin's own evidence at page 78 of the bundle.
Yeah.
And what is said at little 1 is the jurisdiction for this case is DIFC, as all the transactions and meetings related to the policy took place in DIFC area. And then you've got a couple of paragraphs down. There's reference to an office. And then during my transaction in DIFC area, all illustrations and documents were pulled out from their DIFC office, which was the bank end and the administrative office. What there isn't there in my submission is any specific evidence of any specific meetings relating to the conclusion of the contract. It's all incredibly vague. Now, Zurich's evidence is that the contract, and I'll perhaps just show you that. It's at page 92 of the bundle.
Yeah.
And it's paragraph 7C. There are no records of a claimant meeting with anyone at the defendant or having attended the defendant's DIFC offices prior to November 2019. November 2019 being the date when it gave up its license, because That's when it ceased to have any kind of establishment in the DIFC physically. Nexus Insurance Brokers LLC, through whom policy was purchased, is authorised by the UAE Central Bank, and its head office is onshore Dubai. The defendant has no record of any meetings that Nexus had with the claimant in connection with the policy. So the point is that the policy.
Where do I find the policies?
The policy. Well, there is a policy schedule and terms. Yeah. It starts at page 207.
It gives no indication of where it was entered into.
Well, it doesn't. What you can see is that the schedule, which is dated 29th of September 2015, when the policy was incepted, you can see at the bottom, it says signed in the Isle of Man, which is, of course, where we're incorporated and regulated, on the date of the schedule for and on behalf of Zurich International Life. And there's a little signature of the company secretary and the defendant's registered address in Douglas in the Isle of Man.
Yeah.
The document that Mr. Darwin relies on is the form that he filled in and sent to the brokers, or gave to the brokers, when he was when he took out the policy. And Your Honour will find that at page 983. It's worth just having a look at that. This is the application form for the policy. And Your Honour can see that it's on the first page, it's stamped with various stamps. There's a sort of circular one in the top left-hand corner that says received Dubai Post Room 3rd of September 2015. And then there's a Nexus received 2nd of September 2015, Nexus Insurance Brokers LLC. And there's someone has stamped it from Nexus Compliance, again, Nexus Insurance Brokers LLC, Dubai, UAE. And these are all onshore. Their office is in onshore. If Your Honour wants, I can show you an email that Mr. Darwin sent to Nexus, admittedly in 2025, but that shows the onshore address.
I see they describe themselves as Dubai, UAE, which
it is, although, I mean, I can, if you want to just look very quickly at page 89. This is an email that Mr. Darwin relies on in relation to the merits of the claim. It's from 2025, but it's an email involving Nexus. And there's an email from Nexus, and you see Nexus's address, downtown Emaar Square, building number 1. That's squarely onshore Dubai.
Yep. Yep.
So just going back to the application form, I'm not going to take Your Honour through it all. It runs to page 1002. Mr. Darwin says that something in this form shows that there was a meeting in the DIFC. With the greatest of respect to him, I've read it and can't see what it is. He can enlighten us when he makes his submissions. But I would just, on the very last page, Your Honour will see this is page 1002 in the bundle. There's an important information notice.
Yeah.
And Zurich International is a business name of Zurich International Life. It's fully authorised under the Isle of Man Insurance Act. And then Your Honour will see down, it's sort of there's a sentence that says they're registered in Bahrain and they're authorised in Qatar. And then Zurich International Life Limited is registered under UAE Federal Law number 6 of 2007. That's the onshore insurance law, as it was. And its activities in the UAE are governed by such law. And no reference to the DFSA or regulation by the DFSA or operations in the DIFC.
Yep.
So that's the formation of the contract of insurance. Your Honour might recall that the backdrop to this claim is that the benefit of the policy was assigned to a bank very shortly after the policy was incepted. If Your Honour looks at page 18 of the bundle,
Yeah.
this is a letter from Zurich to Mr. Dhawan on the 7th of October 2015, so only a month after the inception of the policy and that application form that we've been looking at, informing him about the assignment to Mashreq Bank. And Your Honour will see from the side, the left-hand side, various addresses are given for Zurich International. Now remember, at the time, I don't dispute that the defendant actually had an office in the DIFC, but it doesn't appear on this correspondence. The correspondence that the addresses that are given are in Emaar Square, Dubai, and then the towers at the Trade Centre in Abu Dhabi. And I can contrast that just to make good this point, Your Honour. If we look at page 1460, right at the back of the bundle.
Yes, I have that.
This is a letter, and Your Honour will see the date, 17th of March 2010. This is 5 years before the policy with which this claim is concerned, and it actually relates to a different policy. And it's not the conclusion of this particular policy, but there seems to be some administrative correspondence. But Your Honour can see there a DIFC address is actually given, and that's 5 years before the events of this contract. So you can see back in 2010 there was some activity in this DIFC office. By the time you get to 2015 and the inception of this policy, you've got the correspondence doesn't refer to the DIFC office. It's concluded through brokers in onshore Dubai. It seems to be received by brokers in onshore Dubai.
And accepted in the Isle of Man.
Well, yes. And they're, well, yes, quite. And so to draw this all together, and given the regulatory background in which Zurich operates, there is, in my submission, no plausible evidential basis that this contract was concluded in the DIFC, because the only thing you've got in the scales in favour of that proposition is the bold statement by Mr. Dhawan that everything happened in the DIFC. But that proposition is flatly contradicted by all of the contemporaneous documentation. There is not a single document that shows that this contract was actually concluded in the DIFC. So now I would like to just quickly turn to the third limb of the of the Courts Law, which is Article 14A(1)(3). Page 713.
Oh, so much rubbish there, okay. Yep. Yes.
So here, what the court is looking for is a claim arising out of or related to an incident or transaction relevant to the DIFC bodies or DIFC establishments, their own activities, or those related to the activities of the employees in any of them that take place wholly or partly within the DIFC. It is, I think, not very happily worded, and that may be because we're looking at the official English translation rather than the original Arabic. But I think Your Honour can get the sense of it from the commentary on the predecessor article in Carafi, which I set out in my skeleton, which is probably the convenient place to read it, at paragraph 33, where the Court of Appeal I might just allow Your Honour just to read that quick passage.
Yeah. That may just read the first part of that if there was here about differences in the law at the moment, but if there was an incident in Dubai, a misrepresentation in the DIFC, a misrepresentation relating to some term of the insurance policy which led to loss and damage, that would be enough to bring within the DIFC jurisdiction.
Yes. So what the court is, what I think the gloss that Carafi puts on this particular lip, I don't think it is materially changed, is that you're looking for some element of the cause of action arising in the DIFC. And so, yes, if a misrepresentation were made from the DIFC or in the DIFC, and that's why, Your Honour, just again standing back and looking at the overall structure of Article 14, you can see its logic, because the first limb asks, well, who is the defendant or the claimant? And do they have a nexus with the DIFC because they're a DIFC establishment? And then limb 2 says, well, is there a contract that has a nexus with the DIFC because the contract's concluded or has got to be performed, etc., in the DIFC? And then the third limb asks the question, well, did some event relevant to the claim happen in the DIFC? So you suffer some loss in the DIFC, or there's an incident, or none of it is very happily worded. But my submission is simply this: that Your Honour doesn't need to get into the technicalities of what might be sufficient to attract this limb.
The problem with that construction is that it doesn't give much, fairly broad meaning to the words relevant to the DIFC bodies or DIFC establishments.
It does. The wording there, relevant to the DIFC bodies or DIFC establishments, is new wording in the court law. It wasn't present in the old judicial authority law. It's not quite clear what they do mean. But in my submission, Your Honour doesn't need to get into the weeds on that, because one, I say we're not a DIFC body or DIFC establishment. And two, there isn't any incident or transaction that occurs in the DIFC. Certainly, Mr. Darwin can't establish a good arguable case that there was.
So
And that's,
what's your submission as to jurisdiction on this? Do you determine whether it's relevant to the DIFC bodies or DIFC establishments as they exist at the time of the action, or at the time of whatever the contravention may be? I must say, I have very great deal of difficulty with this section.
yes. I mean, it isn't easy. I mean, if Article 14A3 was simply was talking about incidents or transactions relevant to DIFC bodies or DIFC establishments, one might think it substantially overlaps with 14A1. And so it must be looking at something different. And so I think that is looking at, in my submission, the events of the claim at the material time when the claim arises. And that's what I want to address you on, because the particulars of claim do not say when the material events relevant to the claim occurred. So they don't explain when the relevant communications took place from Zurich to the bank, because Your Honour will recall the gist of the complaint is that Zurich informed the bank that Mr. Darwin had ceased paying on his premiums, and that as a result the policy was he no longer had cover. Mr. Darwin in his particulars doesn't say when he alleges that took place, but actually we can see roughly when it took place, because if Your Honour turns to page 32 of the bundle, this is the this is the complaint that that Mr. Darwin sent to the Isle of Man Financial Services Ombudsman Scheme. And if Your Honour turns over the page to page 33, Your Honour can see he's asked various questions. When did the problem, this is in the middle of the page, when did the problem you are complaining about happen?
Yeah.
And he gives a date, the 23rd of December 2021, and says 2 or 3 months before this. And then you can see underneath, when did you first become aware of the problem? 23rd of December 2021. So I infer that he found out about the problem in December 2021 and thinks that the relevant communication occurred a couple of months before this. The relevant point is that this is all some time after Zurich's license expired in 2019 and it ceased to carry on business in the DIFC. So there is no evidence that
is there any evidence that Zurich or any company, the Zurich Group, I put it broadly, did notify the bank that Mr. Darwin had ceased paying premiums?
Any evidence in relation to that's not in the bundle. That's, as it were, all to be addressed on the merits. What we're looking at here are the allegations that Mr. Darwin makes and whether he can establish a plausible evidential
I appreciate that. But if it could be shown that Zurich notified at a particular time it wasn't a DIFC body or DIFC establishment, that'd be relevant.
Yeah,
Oh,
it would. I don't have that material in the bundle, for your honour,
right,
unfortunately.
Right. So
this is the best we can do. But what your honour can see is that this complaint arises in 2020, 2021, after 2019, when the defendant has ceased operating in the DIFC. So in my submission, what there is no case, let alone a plausible evidential basis, to support the proposition that a material event relevant to the claim, let me put it like that, occurred in the DIFC. And so however you construe Article 14.3, there's no material event relevant to that claim occurred in the DIFC, because the contract wasn't concluded in the DIFC, and this issue as to communication with the bank occurred after the defendant had ceased operating in the DIFC. So even if there were some argument, someone sitting in an office somewhere in the DIFC had sent some email or made a telephone call to the bank, that wouldn't have happened from the DIFC. So that brings me, Your Honour, and I'm conscious of the time, but there's obviously quite a bit to go through. To my third point, which is the issue of the UAE insurance law, which raises a slightly different point, namely whether this court's jurisdiction is excluded by the federal insurance law, which was law number 6 of 2007 and is now law 48 of 2023.
You accept I don't have to decide this if I'm with you on the other points?
Yes, that's correct. If Your Honour finds...
I'd be restrained having regard to the fact Mr. Dhawan is appearing in person.
Yes.
You go on, I just wanted to clear that up.
No, this issue would only arise if Your Honour concluded that the claim fell within one of the other gateways, because this point is as it were, notwithstanding that, the court's jurisdiction is excluded by a federal statute. As far as I'm aware, this is the first occasion on which a point has been taken in relation to the UAE insurance law in its current form. Although, as I said in my skeleton, there's a decision of the Court of Appeal in a case called Horizon Energy at Al Bahara on the materially similar law that preceded it, the federal law number 6 of 2007. I'm going to come to that decision in due course, but I'd like to start by taking Your Honour to the critical parts of the UAE insurance law. And Your Honour will find it at page 119 of the bundle.
Yep.
And the first thing that Your Honour will note is that this is not a mere Dubai statute. It is a UAE federal statute that applies across the Emirates. And questions of its application are dealt with in Article 2, which Your Honour will find on page 124. And Your Honour can see that the application of this legislation is not territorial, but is based upon the identity of the insurance company.
Yeah.
Because the provisions of the law apply to insurance companies and also holding companies, but it does not apply to companies operating in the financial free zone unless the law provides otherwise. So this law does not apply to insurers who are regulated by the DFSA, providing insurance business in the DIFC, but it applies to onshore insurers who are providing insurance and reinsurance outside the financial free zones, so in onshore Dubai. So what you essentially have are two abutting spheres of regulation. So the DFSA regulates insurers like our connected company, the other Zurich that's regulated in the DFSA and that carries out insurance in the DFSA. The DFSA regulate those entities, and the UAE Central Bank regulates insurers who are operating outside of the financial free zones. So this defendant, Zurich, is squarely within the ambit of the law, and that's why, as Your Honour saw on the application form that Mr. Dhawan referred to, it referred to Zurich being regulated by the UAE Central Bank under, and then at the time it was decree number 7 of 2000, decree number 6 of 2007. It's now decree 23. So the defendant is squarely within the ambit of this law. And then at Article 179, sorry, page 179. There's Article 101, which deals with claims and the settlement of insurance claims. And there is, firstly, an obligation on the company to process insurance claims. And then at 2, if a dispute arises over an insurance claim or if the stakeholder objects to the clarifications, the stakeholder may file a complaint to the Banking and Insurance Dispute Settlement Unit, referred to herein above. And then at 4, the Banking and Insurance Disputes Unit has to set up a committee to settle disputes arising from insurance contracts. And the committee is chaired by a judge. And then at 5, there are rules about when the insurer can challenge. Essentially, if the value of the compensation is less than 50,000 dirhams, the insurer is stuck with it. But if the compensation is more than 50,000 dirhams, the insurer can challenge in the courts. And then 7 is the crucial sub-article.
Yeah.
Cases arising from insurance contracts, business services should be inadmissible if they're not presented to the committees. And if I could just take, Your Honour, because I probably should, to page 112 in the bundle. This is the administrative decision that actually established the committee. And if you want to turn over the page to 113, Article 1 gives some definitions. So you can see company is an insurance company established in the state as well as a foreign insurance company licensed to engage in an insurance business in the state. That's Zurich. Insurance disputes are disputes arising from the complaints of policyholders, beneficiaries, or affected stakeholders against the company. So it includes the insured, although would be wider. So, for instance, Mashrek as the assignee might be able to bring a complaint if it wished to. Article 2, 3 There's an obligation on the committee to consider the disputes impartially and objectively, taking into account legal provisions relating to the subject of the dispute. So this is in essence a court. It's chaired by a judge, and the committee has to consider insurance disputes.
What's an insurance dispute?
It's defined in Article 1. It's about the 11th definition down on page 113.
So it doesn't necessarily have to be, you say, a dispute arising under the policy. So this doesn't, let me ask you this directly. You said this case, as I understand it, really results from the allegation being that Zurich gave the bank false information as to the status of a policy. Does that fall within this these provisions?
In my submission, it does, because it's a dispute arising from a complaint of the policyholder in relation to something arising from his policy.
Yeah.
And I should say it's not entirely clear from the particulars on what basis the claim is put. For instance, there's an allegation of breach of confidence, and it's not entirely clear whether it's said that there's a contractual term in relation to that, or whether it's there's some other source of it.
Take a simple case, and I'm not saying it's this case. The insurer, in answer to an inquiry from a bank, informs the bank that there's no policy in existence. That's wrong, and the actual insured suffers loss. Does that arise out of the policy? As the representation as to the state of fact? I can understand this dealing with claims under the policy, and rights to avoid the policy and the like, but
I mean, if you step back, Your Honour, you can see that the policy behind, in my submission, it would depend on precisely the relationship between complainant and defendant, because the purpose of this provision is to establish a regime to adjudicate on disputes between an insured and their insurer, where that dispute arises in relation to the policy. And it doesn't necessarily, in my submission, need to be an insurance claim, but it has to be something.
They're wide words which need to be considered, but which still nevertheless need to be considered in context, in relation to.
And so there might be a difference, just to explore Your Honour's hypothetical, between a situation where there is an insured and an insurer, and the insurer says something incorrect about a policy which in fact exists, and the situation where, say, there are two parties and there isn't in fact a contract of insurance, but let's say that an insurer falsely says that there is a contract of insurance, and as a result something happens, and then when the truth is discovered, the complainant suffers loss. In that situation, I can see that there might be an argument about whether the complainant would fall within the ambit of the committee, because there'd be an issue there about whether the complainant is actually an insured, because in truth there is no insurance policy and there never was. But that's different from this case, where Mr. Dhawan is the insured. He took out a policy of insurance, and his complaint is that the insurer made statements about the policy that were incorrect.
And you could add one further factor, I suppose. The complaint's a complaint of breach of confidence. And the confidential relationship can only arise as a result, if it's correct, as a result of the.
Yes, yes, I accept that. That's quite correct, Your Honour. So that's how the structure of the legislation works. I just want to show you very briefly a decision of the Dubai Court of Cassation, just to show you how the onshore courts understand this law. And I just want to show you their description of it. You'll find it at page 190 in the bundle. And then after that, I'll deal with Horizon, and then that'll be me done. Your Honour will be glad to hear.
Yeah.
190. So the issue in this case, just for Your Honour, because sometimes these cases can be a little tricky to read, is that the plaintiffs were involved in a car accident, and they filed a complaint against the insurer of the driver who was found at fault, and that complaint was filed to the committee. So this is one where actually there was no nexus of insured and insurer. The complaint was against the insurer of the driver at fault, and the insurer objected on the grounds that a complaint hadn't been made to the insurer first. Because if you recall the structure of Article 110, it said the company will adjudicate on the insurance complaint, and then, if the insured or the stakeholder's not satisfied, you can complain to the committee. And what the insurer argued was, you have to come to us first, and then you can go to the committee. And the Court of Cassation said, no, that's wrong. You can always just go to the committee. And the relevant text is in the middle of the page. Your Honour might see a square bracket.
Yeah.
And then the words, this means that the legislature, and they've discussed the law just immediately above it, has established a specific course of action for litigation proceedings with regard to insurance disputes involving insurance companies only, and has conferred upon the committee referred to in that law the exclusive jurisdiction to adjudicate on such disputes arising from insurance contracts, operations, or services, and also permits the committee's decisions to be challenged, etc. Hence, the jurisdiction of the Court of First Instance is confined to hearing the appeals by parties to the insured disputes decided on by the committee. And then they go on to say in the next sentence, it's not this is about 4 lines down, it's not a mandatory prerequisite. The aggrieved party must make a complaint to a submission of the claim to the insurer before referring the dispute to the committee. So that's actually what was decided. But I rely on this for the explanation that the Court of Cassation gives about the purpose of the regime. Namely, it's an exclusive jurisdiction to adjudicate on disputes arising from insurance contracts. So I now want to come to the decision in Horizon, which Your Honour will find in the bundle at 461. Sorry, 1461. Sorry, my mistake, Your Honour.
Yep.
So the issue in this case was jurisdiction in a claim by the insurer against the insured. And the particular issue was the construction actually of a jurisdiction clause. And if Your Honour goes to page 1462, the start of the reasons, Your Honour can see in the middle of paragraph 1 a reference to the fact that the relevant insurance policies contained a jurisdiction clause which subjected the parties to, quote, the exclusive jurisdiction of the courts of the UAE.
Yeah.
And it's essentially what the insurer argued unsuccessfully is that the exclusive jurisdiction of the courts of the UAE should be construed as meaning the committee. And therefore the DIFC court did not have jurisdiction. So there was no issue in this case about any of the other gateways.
I see.
The only basis on which the DIFC court would have had jurisdiction is if the clause was construed as a clause whereby the parties opted into the jurisdiction of this court.
Yeah.
And you want to concede from paragraph 2 of the judgment, the court saying, this is of the old 2007 law, but they're not materially different. This court does not accept that the asymmetric dispute resolution mechanism provided by Article 10 operates to deprive the DIFC court of jurisdiction to entertain claims by an insurer against the insured, including a negative declaration to the effect that the relevant policy has been avoided.
Yep.
And I just want to just take you a little bit through the factual background of this case, because it's important to understanding the extent of its holding. At paragraph 8, Your Honour can see that the insured actually made a complaint to the committee. It's referred to in the judgment as the insurance authority. And then over the page, and the complaint, I should say, was because the insurer had not paid out on the claim. Over the page at paragraph 11, you get the insurer applying to the DIFC court for a declaration that the policy should be avoided. The insured challenged jurisdiction, saying, no, it should be referred to the committee. Bizarrely, the committee said that they had no jurisdiction because there was an arbitration clause, even though all parties agreed there was no arbitration clause. And that is one of the exceptions to the it's in the legislation. I didn't show it to Your Honour, but there is a rule that says if there's an arbitration agreement, the committee's got no jurisdiction. So at that point, the insured went to the courts of Sharjah, and that is, as it were, the backdrop to which the court had to decide whether the DIFC court had jurisdiction. And Your Honour will see on page 1463, at paragraph 19, the jurisdiction clause in full. And then I'll take Your Honour just to the Court of Appeal's reasoning. This is it starts at page 1471.
Yeah.
And really the core of the court's reasoning, and I'd invite Your Honour, if Your Honour needs to decide this point, to read paragraph 76 to 83. But what the Court of Appeal essentially decide is at 78, 79, there's a general obligation on insurance companies to process claims, and then a disputed claim may be referred to the committee. And it is clear that complaints can only be referred by the insured. And they say it does not by its terms nor by any necessary implication have, this is paragraph 79, have a preclusive effect preventing the insurer from seeking remedies in relation to disputes arising out of the insurance contract. For instance, an action to recover an insurance payout where the claim was fraudulent, or the recovery of a premium. And then at 81 and 82, there's reference to the fact that it's asymmetric, and then nothing in the insurance law prevents the parties from contracting out of the regime. So the Court of Appeal's conclusion is that this regime is one-sided. It's a regime about where the insured makes their complaints, not about where an insurer can bring proceedings. And they also make a conclusion about contracting out. So I mean, I don't obviously dissent from that analysis, but it's not this case. What the Court of Appeal, and actually Justice Giles at first instance, didn't decide was whether the insurance law was preclusive from the perspective of the insured, i.e. whether the insured must raise a complaint before the committee and await a decision, and the court's role being confined to an appeal, or whether the insured has the option of going straight to court. And in my submission, the insurance law does have that effect, because Article 1017 admits of no other construction, that claims shall be inadmissible unless they've been brought before the committee first. And if the Court of Appeal's right that claims means claims by an insured against an insurer, then that must necessarily give Article 1017 a preclusive effect. And that was the view of the Dubai Court of Cassation in the decision I showed you, because they referred to the exclusive jurisdiction of the committee. And so the result is that this claim by an insured is inadmissible, at least until there's been a decision by the committee. And then the court's role, if the court had jurisdiction at that stage, would be consideration of the decision made by the committee. But Your Honour should decline jurisdiction at the moment for the reason that there's been, well, it's not said that a complaint has been made to the committee, let alone that a complaint's been determined. Now, in Horizon, the Court of Appeal held that parties could contract out of the regime. That's at paragraph 82. Now, in my submission, that conclusion was necessarily obiter, because having found that the insurance law doesn't preclude claims by an insurer, it didn't need to go on and make any finding about whether the parties could contract out, because the result of its first finding is that there's nothing that you need to contract out of. And in my submission, the conclusion that the parties can contract out has to be approached with some care, because insurers invariably contract on the insurer's standard terms. And the risk in the Court of Appeal's analysis, if it's right, is that the insurer could compel the insured to contract out of the committee system. And that starts to become a surprising result when one thinks about the policy behind this regime, which is to have a specialized tribunal to deal with complaints by consumers. And one can see why. I mean, imagine an insurer, Your Honour, had an insurance contract that said, you may only sue me in the DIFC courts. In those circumstances, an insurer, if the Court of Appeal is right, the insured has to bring a claim in the DIFC court. And the result of that, obviously, I mean, just to take one facet of this, as I understand it, before the committee, there's no adverse cost regime. So if Mr. Dhawan were to make a complaint in front of the committee and lose, he wouldn't bear the adverse costs. But in the DIFC courts, it's an adverse cost regime in the common law system. And you could see why it would be to the advantage of an insurer to compel the insured to contract out of the committee system and sue it in the DIFC court, where the insurer can fund lawyers.
The same would apply to any exclusive jurisdiction clause.
Well, it would, yes. It would. Now, in my submission, Your Honour doesn't need to get into all that, partly because the court doesn't have jurisdiction on any of the earlier bases, but also because there's no jurisdiction clause in this case, and so no issue about contracting out. And I just want to show you the clause in the policy at page 211 in the bundle. These are the terms and conditions, just so Your Honour's got them.
Yeah.
The policy terms, and the relevant term is on page 238.
Yeah.
And it starts, the policies governed by and shall be, this is clause 21, shall be construed in accordance with the laws of the UAE, and the company will submit to the non-exclusive jurisdiction of any competent legal authority in the UAE. Now, in my submission, the use of the word competent is what deprives this clause of being a jurisdiction clause in the sense in which it was meant in Horizon, because the word competent assumes that the court in which the proceedings are taking place already have jurisdiction. So this is not a clause, as was in Horizon, that could be construed as conferring jurisdiction on a court that didn't already have it.
Yeah.
So it's out with the scope of what was being discussed in Horizon.
I understand.
I think, unless I can assist Your Honour further, those are all my submissions. I've taken all the material that I think Your Honour needs to see, unless Your Honour's got any questions.
Thank you, Mr. Watson.
Thank you, Your Honour.
Mr. Darwin?
So, thank you for his presentation and the nice way he's put it too. I'm not a professional lawyer. I'm a very simple human being who has gone through all this. But there's one point which I would like to say right now on the last point, which is created on the book, which he's shown us on page 211. Fortunately or unfortunately, I get this book from when I signed the contract. It's the same book by them. This also has a page which I have submitted in my memorandum and articles.
Sorry, Your Honour. I think Mr. Darwin is referring to the bundle, page 211.
Yeah, bundle 211, in which he has put his book, whereas the one which I got was this when I signed this contract. We are referring to the same point of jurisdiction, in which I have pointed out Article 710B. And I would like to read just this content where he's spoken about competent and non-competent court here, non-exclusive jurisdiction of any competent legal thing. The book which was given to me reads as follows, and I like to read it. When the policy owner is resident in the United Arab Emirates, then the company will submit to the jurisdiction of any legal authority in the UAE in respect of any litigation arising out of the policy, and the policy shall be interpreted in accordance with the UAE. It has got no wording of competent, incompetent, or anything like that. This is the document which I have. And I have put that in my bundle also. These sheets marked very clear. First of all, I would also like to say, none of the documents which he's talking about as a contract has ever been signed by me or received by me. The form which they make us fill is signed and taken. I also have a mail very recently when I asked for my original policy with my signatures. And the message, which was an email which has come from Zurich, says it was burnt and damaged in a fire, and we have no such documents. It is on page 103 to 108 in the bundle. So ideally, what I'm trying to say is,
I'm sorry, Mr. Dhawan, what page? What page did you say?
1003 to
You're referring to before as a page 1459 of the bundle.
Page number is 1003. If you read the mail, the documents that you have requested was damaged in an incident. And it's not for one policy. I have yet to receive documents original of any of my policies. The only document which I have is the form which they make you fill. They take the signature, and then the original policy never comes to you. The documents which they give you, as I just showed you, was this booklet to me. And now the booklet which is being produced by the law office is another document which I have not even seen.
Mr. Dhawan, what I have to decide on this question is whether, putting it in a layperson's term, whether you've shown enough to show that there's a good arguable case that the court has jurisdiction under one of the limbs of Article 14. That is either that the court, sorry, that the company, the insurer, that's the company with which you took out the policy, is at this time a DFIC establishment or a DFIC body. Mr. Watson has said, given some reasons why it's not. You want to say anything in response to that?
Right, I do. What we as laymen understand and what we were told is for jurisdiction of any contract which is signed ever is first the place where it is signed, which was DIFC, which I have said enough times. When my medical had to be done in 2010 because I was a blood pressure case, which document he has already proved, I was in DIFC sitting and somebody from the top floor came, talked to me those questions about my health conditions, and then left, which was the insurer, which was again in DIFC, and the letter which I submitted was also DIFC. Then later in 2015, the same claim form was filled, for which the 4 pages, I don't know why my law friends did not put those 4 pages, which are very crucial, which were from page number, I think 9 to 11, right? Which very clearly showed, yeah, it is on page 993 to 996, where again I was called in DIFC and they took my doctor's details and they referred to all my 5 policies there. It is written in my bundle, whereas when the law firm submitted that, they removed those 4 pages for whatever reason. They don't know. I don't know. They didn't want to show the link between the 4 or 5 policies. That was also in DIFC.
Yeah.
Okay, so I was again asked questions in DIFC about my health. They took my doctor's details, this, and then they issued the policy later on. Okay, based on that. Now, first part, what we know is if that area is there, the jurisdiction happens. Second, what I know is if 2 companies agree to sign an agreement that it will be the DIFC code, whether they are DIFC entity or not, it can work with that. And the third part, which is in this clause which I have, which very, very clearly states they will come to any court of jurisdiction in the UAE, then with such a big law firm sitting in there, what are they afraid of talking to me in there? It's a breach we are talking about, and we're not concentrating there. They're talking jurisdiction for what reason, I don't even understand. Last part, they're saying I did not take the steps of going to various places. If you've seen my documents, the people at Zurich over the phone, which is the call center, Me Help and all that, and the people from the Nexus Insurance, who are my advisors also like Zurich, have conveyed to me the various steps. And you can see I've gone to not only Zurich, I've gone to the Me Help, I've gone to Nexus, and I've gone to Isle of Man. I've been made to run from pillar to post advice. So I've gone to all the places, and eventually, when nobody was listening, even in Isle of Man, I told them, then finally, if nobody is listening, I have no other choice but to go to DIFC and take it on. And that's what I did. I had no money. I've really been into trouble. I'm sitting and surviving in UAE after so many years, after actually now owning so much wealth and stuff, and now on a rented apartment, just because I didn't have the money. And that is why it took me time even to file this claim. I've only been intimidated by the law firm also, including a cost sheet which they put yesterday or day before, which says for an intern who has 0 working hours, they billed 2,100 dirhams per hour on me because
Mr. Dhawan, my job is not to consider the merits of the case or how you've been treated by the insurers or for that matter by anyone else. I have to decide, according to the law, whether the DIFC court or whether I have jurisdiction to determine your claim. All I'll be determining in this case is whether on the material available I have jurisdiction or I don't have jurisdiction. Now, anything else is for this purpose, whilst I understand you may have considerable grievances, got nothing to do with what I'm doing. So I understand what you've said so far about the contractual arrangements, and I understand what you've said about the association this case has with the DIFC, and I'll consider the evidence in relation to that. But I don't go outside that.
Perfect. So, my lord, then my first point that my events all happened there, and this, which is the overrider which I have, which says anything. They have not given me any document after this to change this or move this away or whatever. Plus, they themselves consider that the office is still there. Being unregistered is another part. But as you understand, insurance, people never sit in offices and do contracts. They walk all over the world and they do it. That's another part. In terms of the claim, it is not an insurance claim to be 100% precise that, oh, I died or something else happened. It is just that they have done a breach and it was done in the area which is the jurisdiction of DIFC because all deals were done there, as far as I'm concerned. I am not having any more further things to say because I don't know what else to say.
Well, thank you very much for that, Mr. Dhawan. That's very helpful. I'll decide whether I want the material which I've got, which is your reply statement, the material you've provided, and the material the insurers provided, whether I have jurisdiction. And I'll give a judgment as soon as I can.
Yeah, and I'm yet to get my original contract signed by them because they've never delivered a contract to me. So if they can change those documents with the stamp, I'm not even privy to that.
Thank you. Very well, thank you for dealing with it so efficiently. I'll reserve my judgment. Thank you.
Thank you, Your Honour.
Thank you for your time.
Thank you.
Thank you, Matthew. Bye-bye.